Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Friends, welcome back. We're once again in Murray, Kentucky, down at Calloway County with attorney Jeff Roberts. Jeff, how are you?
I'm doing good. How are you, Jim?
Good, buddy. You know, when we started prepping for this episode, you had mentioned that lately you've had a group of phone calls that have all kind of had a common theme. So I thought, you know what, why don't we turn this into a podcast episode and talk about the importance of, again, the company doctor scenario that we've explored in a few other previous podcasts. But kind of talk to the audience about what's been going on, and let's use that as a springboard to the conversation.
Sure. I've had a few potential clients call in and speak with me about their work-related injury that have had at least been told by the company that they had to go to certain doctors, that the only way their treatment's going to be covered is if they go to who the company tells them to go to. And, that's not what Kentucky law is. And, in fact, one of them, they told the person that, if they didn't go to the company doctor, then their claim would be denied because they had to go to the company doctor for their claim before it would be accepted as a workers' compensation claim. And that just is not Kentucky law. Kentucky law is very, very clear that an injured worker gets to pick their medical provider. They get to pick the doctors that they are treated with. They get to pick the physical therapist that they treat with. They get to pick the pharmacy that fills their medications. They get to pick where they go for diagnostic testing. Kentucky law is clear that the injured worker has the right to choose their medical provider. I was involved in a case that went up to the Kentucky Supreme Court over that issue in regard to pharmacies, on whether a pharmacy was considered a medical provider where the injured worker had a provider choice and got to choose, and the Supreme Court agreed with me and my client that, yes, the injured worker gets to pick the pharmacy that fills their prescriptions. So that law is very well settled in Kentucky, but there are some companies still that want to try to tell their workers that you've got to go to the plant medical department for the work-related injury, and then let them tell you what doctors that you need to go to. And, I have faced this issue my entire career. I've been doing this for over 32 years now, and this occurred with employers that I dealt with back when I first started practicing that are no longer in business, and I still see it with employers now today. And it does, at least what I've seen, it tends to occur more with facilities that do have a plant nurses department or a plant medical department, that they tend to do this. Not all of those do that, don't get me wrong, but I rarely see this in a facility employer that does not have that type of a plant medical facility there. And I've litigated this issue out several times in cases. I've had cases where in the past where they have denied because they didn't go to the plant medical initially, saying, well, they denied the claim for whatever reason. They went to their family doctor first because they were off work, and went to the family doctor for the issue. A lot of plant medicals, they aren't open over the midnight shift, and the person got off work, went to the family doctor instead of going back to the employer. And in one of them, actually, the employer ended up paying my attorney fee in that case because the judge said the way they treated my client was unreasonable in denying the claim and requiring them to litigate this claim out, and ordered the insurance company and the employer to pay my attorney fee instead of my client having to pay my attorney fee. That doesn't happen very often, but if it's an egregious situation, that is something that can occur from that standpoint. But Kentucky law is clear, has been clear at least since I started practicing in 92, that the injured worker gets to pick their medical provider, and the insurance company nor the employer gets to tell them who to go to.
Well, and I am still, as many episodes as we've done, and this is episode number 93, as many of these episodes that we've done about workers' comp, I'm surprised at the games that get played. And it's sad almost. I mean, but when I look at a case like this, or a situation like this, where the company is saying, no, you got to go see our doctors, you've got to go see this, and really try to take advantage of a situation when somebody's literally hurt, at the plant or on the assembly line, or wherever out on the job site. If I want home cooking, I'll go to Martha's on 641. I don't need to, I don't need to expect that from my own company. But that goes on. These are the games that get played.
Exactly, and I agree with you from that standpoint. And there's you talked about home cooking, and I go to Rudy's instead of Martha's. But Martha's is very good as well. But Rudy's is kind of my office away from the office, so to speak. But I think it is home cooking. Now, I think there's a reason why I've seen this for 32 years. There are some issues you see pop up and then they go away when they get shot down. The company doctors and the insurance companies and the employers will tell you, no, we're not engaging in home cooking. The company doctors aren't saying things, saying the injuries aren't work related that are, or that they're not as bad as they are. But the only reason that I can come up with after thinking about this is why an insurance company or an employer would clearly flaunt what Kentucky law is for so long, and go to the point that one got sanctioned in the form of attorney fees and costs in cases, and they did it, even continue to do it some even after that, is because they think that, in my opinion, I think insurance companies generally look at what their bottom line is, and I think they think that, okay, it's going to come back to bite us a few times here, but the ones who don't go to an attorney, who don't fight this out, we're going to save a lot of money on their cases, so it's financially better for us to continue to do this policy, even when it's clearly against Kentucky law. And unfortunately, there's not much, other than a few occasions where you can get attorney fees, there's just not much enforcement mechanism when insurance companies do this.
So let's kind of talk about the reason behind the game, and the reason a company might say, no, you need to go see this doctor or this doctor. You're thinking, okay, hey, they're being helpful, they're being convenient, they really care about me. But the moment you are injured, you become an expense, and they start looking at the numbers often. And I think I'll let you explain. I'd rather have you explain it as an attorney rather than me try to put words in your mouth. But why would a company try to send you to a specific doctor or group of doctors?
Well, I mean, they're going to disagree with me, but I think it is because they think it's ultimately going to be better for their bottom line. There are, for instance, for a while there, anytime someone had up in the Louisville area had carpal tunnel syndrome, there was a doctor up in that area who was of the opinion, incorrectly, in my opinion, of the opinion that cumulative trauma does not cause carpal tunnel. That, someone who types 8 hours a day and develops carpal tunnel, well, the typing 8 hours a day had nothing to do with the carpal tunnel, according to this person. It's because they're a female, or because
it's their side job as a mechanic.
Yeah, well, no, it had nothing to. It had nothing to do with work. And so, this person had this viewpoint. This doctor had this viewpoint, and when it got out that this doctor had this viewpoint, amazingly, a lot of companies up in Louisville that had, if the person had an ankle injury, they tripped over something and broke their ankle, they didn't send them to this doctor. It wasn't the company doctor for ankle injuries, but if it was a carpal tunnel or a cumulative trauma type injury, this was the doctor they always recommended, because they knew this doctor was going to, in my opinion, they knew this doctor was going to say, this is not a work-related injury. Carpal tunnel is not cumulative trauma is not a thing, and there's carpal tunnel is not from cumulative trauma, even though literature and all the other doctors around were saying, yes, it is. That's the way and so this guy was being used all the time. Or trying to be used all the time, and when they couldn't get him, the doctor to be the treating doctor. That's who they would go to for their evaluation for evident, their expert they would use if we had to litigate the case. And when his credibility finally got shot, because he said the exact same thing every time, and all the judges learned that, then he quit getting business, as much business at that point. And the only reason you would stop using him is because, okay, he's not helpful for us anymore. So while they would disagree and say, well, we're trying to get them to the best care, and while I would hope that be the case, my experience over 32 years is that's not the case, because the doctors that I see companies use and insurance companies send people to for treatment purposes are not doctors that I would consider to be the best in the field for treating those conditions from there. Now, that's not always the case, but most of the time it's doctors that tend to be very insurance-friendly doctors and tend to say the injury isn't as bad, the person doesn't need the surgery that they may need, or whatever. And to me, it's counterproductive. After doing this 32 years, and I think the medical science will bring it up, will bear this out, even though I'm not a doctor and I'm not giving anybody medical advice whatsoever. The sooner you treat a condition and get it better, the better the long-term recovery is. If you deal with something for 5-6 months before you actually get good treatment for that condition, the chances of of that treatment being as successful would have been if you'd had it a month or 6 weeks after the injury aren't as great. You tend to have better results when something is treated sooner rather than later.
Do it right the first time.
Yeah, exactly. And so what they end up doing, I think, is end up costing themselves money on the back end because the person's recovery isn't as good as it would be. But the worst part of that is the person now has a worse recovery. They're in chronic pain, or they're not as functional as they would have been if they'd gotten good treatment up front. From there, so not only are they costing themselves money in the end, if the person gets to an attorney anyway, costing themselves money in the end, but they're also causing the outcome and the injured worker to have a much worse recovery and outcome, and affecting their rest of their life when there's no need for it.
Wow, unbelievable. I mean, cold-hearted in a lot of these situations.
Yeah.
As you referenced earlier, if there's a facility in the plant, a nurse's station, something like that, there's nothing wrong with going to, okay, hey, look, I cut myself, I got to get somehow some pressure on this, maybe a Band-Aid or something, even a bandage if you twisted an ankle or whatever, rolled an ankle, that's fine. But as far as really getting treated, you've said in previous episodes, you're probably better off going back to your family physician, right? Your family doctor.
Exactly. And I mentioned, we talked before about a Form 113 designated physician form there. And normally, when you're injured on the job, you can pick your family doctor to be your designated doctor, and that's who I recommend people to go to. Hopefully you have a good relationship with your family doctor. And even if you need a specialist, your family doctor can refer you to the specialist, but use the family doctor as your designated doctor who makes the referrals to that, because you hopefully have a relationship, a good relationship, and that doctor is going to send you to the ones he thinks are going to be the best to treat your condition. And
it comes back to your earlier point. Do it right the first time. Kind of, don't prolong this if you don't have to.
Exactly. Your recovery is going to be better the sooner you get treatment, and the better treatment, the better. If you go to the best, you're hopefully going to have the best recovery. Not always, but hopefully that's going to be the case from that. Now, there may be a situation where you can't use your family doctor. As I said before, you get the right to pick your doctors. Now, there is a provision in Kentucky law where the insurance company can have a managed care plan. And if they have a managed care plan, you have to pick a doctor within that managed care plan. Again, I'm saying go to a family doctor, primary care doctor for your designated doctor, and if your primary care doctor is in that plan, that's who you want to go to. If your primary care doctor is not in that managed care plan and they have one, then you got to pick a doctor within that plan, but go to primary and then let them refer you out to other doctors from there. But it's fine to go to the plant medical. If you have a back injury, lift something real heavy and a sudden onset of back pain, go talk to the plant medical about it and let them know that it's happened. There's no problem with doing that. If they say, okay, we're going to, they may give you some aspirin or something like that to and say, all right, come back, give it rest over the weekend. We'll see how you're doing Monday, and okay. I mean, if you're still hurting bad Saturday and you want to go see somebody, go to urgent care, you're welcome to do that, and the law says you can do that. But if you want to wait till Monday and go back in, and they say, okay, let's get you in to see somebody, and they say, well, we want to send you to insurance company Dr. A, no, just tell them, no, I don't want to go to that. I want to go to my family doctor. This is who I'm going to go see. I'll call them up, and I'll let you know when the appointment is. I'm going to call them up and set the appointment up, and do it that way. And they may balk at it from there, but just say, look, I want to treat with a doctor I know. I don't want y'all telling me who to go to. I want to go with somebody I know and I trust is going to do me well. And if they continue to have problems, call an attorney or call the Department of Workers' Claims, because they can't force you to go to a doctor of their choosing. You get to pick who you go to.
Let me take you down just a real small rabbit hole here. In previous episodes, we've talked about the duty to notify. It's when you are injured, you do have to notify somebody up the food chain. If you report to the nurse's station, does that fulfill that requirement?
Most of the time, yes, it's going to fulfill that requirement. In a lot of plants, you have to tell your supervisor, I need to go plant medical. I lifted this, I hurt my back, I need to go plant medical. And they say, yeah, go ahead and go. We'll get somebody to cover your station or whatever. And so most of the time when people go to the plant medical, they've already said something to the supervisor. Supervisors approved them to leave the line and go to the plant medical. And so you've told there. But most companies, plant medical is an appropriate person to report. And the plant medical knows if you report it occurred work-related, they're supposed to report that up to HR as well. So that's going to, I can't imagine a judge. Cover that requirement. I can't imagine a judge is going to say that's not going to be sufficient notice to the employer.
Okay. So you talked just a little bit about the designated physicians form 113. That was back in episode 68. And friends, if you're listening to episode 68, you'll find we split that episode between the designated physicians form and another important form, Form 114, which is an expense reimbursement. Do you want to talk a little bit about that? Because there is a window for that reimbursement.
Yes. A Form 114 reimbursement form is if, a lot of times, especially initially after an injury, when it first occurs, you go to your family doctor, and your family doctor gives you a prescription. You go to the pharmacy to fill that prescription. Pharmacy doesn't know who to bill at that point in time. A lot of times the bill is, they fill it under health insurance. You get a copay. Well, if you pay a copay for a prescription or a copay for your family doctor, keep those receipts. You fill out the Form 114, which you can access online on the Department of Workers' Claims website, or if you're a client of mine, I'll give you copies of those. And that form is to get reimbursed for whatever you've paid out of pocket. If you have to change bandages and you go to Walmart or Walgreens and have to buy new bandages and do that, that's included in there. All of those out-of-pocket costs you incur, you can submit that to the insurance company with the receipt showing what you've paid for, and they will reimburse you, or should reimburse you, for what you've been out of pocket. Now, keep a copy of that, what you send in, keep a copy for yourself, and make the note on the date of that. And the same as regard to mileage. You get reimbursed your mileage for seeking medical treatment. So if you travel 15 miles one way to go see your family doctor, you can get reimbursed that. If you go to therapy, you get reimbursed for the mileage going to therapy.
So your doctor refers you to a specialist up in Louisville or over down in Nashville or something.
Exactly. Like you get reimbursed that mileage, but you have to submit the request in on the Form 114. And as you mentioned, there is a deadline. The regulations say that the Form 114 is supposed to be submitted within 60 days of incurring the cost. So you need to every 45 days is what I would do if it were me. Is make a note every 45 days. I got to submit this in. I got to submit this in, so that you never have one that goes more than 45 days before you submit that request in. Now, if you need it quicker, if you're having to travel to Louisville to see a doctor, that costs quite a bit of money, and so if you need that reimbursement sooner, you can submit it the day after you went. Yeah, you don't have to wait. You don't have to wait from that standpoint. But don't wait more than 60 days. You've got to get that in, and especially with issues with mail and all of that, if you have an email where you can scan it, email it into them, great. But if you don't, you got to send it through regular mail. It could take 5-10 days, especially holiday time, like we're around at this point in time. You could those things can cause a delay, and if you submit it at 50 days, but it doesn't arrive till 61 days, the insurance company may say you're too late, and we don't want that to occur.
Right, that makes sense. And friends, once again, I'm going to reference episode 68, which you can find out on Spotify, iHeartRadio, Apple Podcasts. You can find it right there on Jeff's website, jeffrobertslaw.com. There's a button for media, and then that'll lead you right to the podcast page. All of these show notes have a lot of links to other episodes that were recorded, but also other resources. I think, that, Jeff, I think there is a link in that episode to a standard expense reimbursement form on there to make it easy for them.
I think we
Yeah,
did. I
yeah.
think you did include that. I'm
Yeah.
not going to. I'll give credit where credit's due. I'm not the one who put any links or show notes on any of this. That's outside my knowledge
So
base.
much wrong. You're also giving me the credit for that too. So I
Yes.
really appreciate it.
Yeah.
It's a given season. So there we go. So we've talked about, you're right as a Kentucky worker to choose your own doctor, and that goes to your pharmacy as well. We've talked about the importance of designating a specific physician. This is my designated physician, and let them kind of call the shots in terms of my medical treatment. We've talked a little bit about some of the expense reimbursement and things like that. One of the advantages of having your own doctor or having an attorney work with you who knows how to help you find medical treatment is that when disputes come up, you, Jeff, have done a good job of actually saying, no, we need to go get a second opinion, and we may, this might be a group of doctors over here we want to talk about, try to balance out that imbalance that can happen if you are unfortunately having to get stuck with a company doctor type scenario.
Correct. There's times that that when the treating doctor is recommending, the treating specialist is recommending surgery, or potentially recommending something that may be experimental is not the right word for it, but controversial type treatment for a condition. And frankly, there's times that I recommend my client get a second opinion from someone else. When that is occurring, it's not because I think the treating doctor's wrong, but before a client undergoes something like that, let's get a second opinion, make sure that is the best line of treatment before we go do something that can't be undone. Once you've got open somebody, you can't undo that incision. That is, and so I do occasionally have clients that I recommend you go get second opinions. I have other clients come to me more frequently. Clients come to me and say, "Doctor wants to do surgery. I just soon avoid surgery. I'd like to get a second opinion and see if there's something else we can do," and we do it that way. And there are certain doctors that are super specialists, so to speak, in certain areas, and I know the judges are going to pay attention to what they say. I know most insurance companies are actually going to pay attention to what they say because they know the judges are going to pay attention to what they say. And if I have a situation where they're recommending a surgery, the treating doctor's recommending surgery, the workers' comp insurance doctor is saying, no, I don't think that's what the person needs at this point in time. And it may be, okay, well, let's get a second opinion, go to one of these doctors that I know the judges are going to listen to and the insurance company are going to listen to. And if they come back and say, yes, surgery is needed, then the person can go back to the treating doctor and get that surgery without it being as big of a fight and having to litigate it out for 6-8 months beforehand. That's, in fact, in one of my clients fairly recently, we were able to do exactly that. The doctor was recommending surgery. My client he'd already had one surgery that had failed. The doctor was recommending another surgery. Client was a little leery. The insurance company originally denied. I talked with them and I said, look, this person here is very known for treating this body part. It was a decent ways away from where we're at, but they're very known. They have a great reputation. They're respected by insurance companies. They're respected by judges. Can we get a second opinion from, would y'all agree to go to second opinion with this doctor? Kind of did it in a real nice way, like they had a say in it. They didn't really, but I let them think they did. And so they agreed to do that. And so my client went up there. That doctor looked at it and said he agreed with everything the treating doctor was recommending. And the insurance company doctor had balked on it. The one they'd sent my client to had balked on it. And when they got this other doctor's report, it was emailed to me, I think like 2 days after the visit, and said this doctor recommends the same surgery that the treating doctor is. We're letting the treating doctor know we're pre-certifying the surgery to your client to call and get it set up. So if we didn't go that route and just went straight to litigating the case, it'd have been 8 months later instead of being approved within about 3 weeks.
Well, and that's 8 months of pain. That's
Correct.
8 months of disruption. That's 8 months of, as we started off this episode talking about, of an injury not being treated early and
Correct.
properly, and that may lead to more issues down the road. So again,
Right.
I think, as I've listened to these episodes over the years, when you get into a situation where the insurance company is trying to avoid the more costly procedure sometimes, so they may say, no, we want to go this route, but you have the ability to get in there with this process and say, no, there's another way to treat this. And again, you've got 32 years of experience dealing with it. You've seen a ton of injuries, and you kind of have probably some experience in saying, no, this is generally what should happen. Sometimes it doesn't go that way, though, right?
Yeah, right. Sometimes it doesn't go that way. Yes, I've got the years of experience and the gray hair to prove it on fighting these battles for my clients there. And it very well could, in that case I just mentioned, it could have been that this doctor that my client got the second opinion, come back and said, no, I don't think that's the proper way to treat this. And then my client and I would have sat down and gone over that and dealt with it however we needed to deal with it from that standpoint. But, normally I'm in my experience, the treating doctors usually are the ones backed up by the super specialists versus the insurance company doctor. So when we went up there, I kind of expected that was going to be, but my client also wanted to make sure before they got cut open again, and I understand that completely. If you can avoid surgery, you should avoid surgery. But fighting these battles is something that workers' comp attorneys and sadly injured workers have to go through way too frequently.
Yeah, and that's, again, the more we talk about these things, the more I realize, the importance of getting to an attorney early in the process. If you've been injured on the job, more often than not, you're going to qualify for workers' comp benefits. And yeah, you can do it on your own, but there's a lot of games that are being played, and you may not realize you're getting played. And so having an attorney represent you can probably save you some headaches and maybe a lot of pain down the road here.
Well, yes, that's true. And as I said earlier, I think the insurance companies, the reasons they want people to go to the company doctors is because they think it's going to save them money down the road. The person who's losing that money, if the insurance company saves money down the road, the person who's losing that money is the injured worker. And the person who's not getting the proper medical treatment and is having to suffer with the lifetime consequences of that is the injured worker. And so, if that is occurring, you need to get to see an attorney that handles workers' compensation, whether it's me or whether it's another attorney that handles workers' compensation, because how you feel 10 years from now could be at stake.
And Jeff, you've got a reputation for handling workers' compensation claims all across the state. I mean, I know you've had cases up in Louisville, up in northern Kentucky. You do a lot of work over in Bowling Green, Paducah. I mean, you're kind of all over the state. I know we're talking that's more central and western, but you've also done some stuff in the eastern part of the state as well. You do actually have 2 offices, though, now.
Yes, I do. I have an office here in Murray, Kentucky, where we're at today, and I have an office in Hopkinsville, Kentucky, and Christian County, Kentucky, that I meet with clients at as well. And I've had that office now for a little while. up there. Obviously, I've been in Murray 32 years. I've treated or represented clients out of Hopkinsville, Christian County over that 32 years as well. But I now have a dedicated office up there in Hopkinsville to meet with clients there. I just have one phone number though. To me, it's just a lot easier to have one number. That way, if clients call, they get in touch with me. They don't get somebody answer and say, "Well, he's at the Hopkinsville office. You got to call this number." I'll get the phone call regardless if I'm available to talk to you at that point in time. Phone number to reach me if you do have any questions or want to talk to me is 270-753-0053. Again, that's if you're in Christian County, if you're in Murray, if you're in Louisville, Pikeville, Paducah. That's the number to call to reach me. If you want to use an 800 number, it's 1-800-844-5108, so you can use the 800 number as well. And that's going to be the best way to reach me is by phone. And
Yeah, and I think it makes it easy. You can also, there's a contact us form on the website, jeffrobertslaw.com. But, if you're not in Calloway County and you're wondering, well, I'm hurt in Jefferson County, or I'm over in Fayette County, or I'm up in, Boone County, why should I call Jeff? As somebody that's just known Jeff for a lot of years, I'm going to ask you, go out and Google the Roberts Law Office, Murray, and look at his Google reviews. I mean, you're a solo practitioner, Jeff. I mean, yeah, you've done it for 32 years, but you're the attorney in the office. And to see that many 5-star reviews with comments from your clients, those are earned. And it's just amazing to read those comments and people just saying, this is why. It was the communication. It was the straight talk. It was Jeff made it understandable. Jeff really cared. I understood how, I could trust Jeff when he gave me advice. All those things come through in that. And I think, that's the benefit of not only just having the time in the saddle, the 32 years that you've had, but it's having done it right. And again, I really admire the way you've run your practice.
thank you. I very much appreciate that. If you go to the website or go to Google and see the reviews, as you and I've talked before, I do have motto's not the right word for it. I don't know what the proper word is, but I do have kind of a way, a standard I try to run my office by, and that is to provide small town service and deliver big city results. And if you go to a small town, the service you get and the way you're treated, to me, is different than going to a big city. From that, I try to provide that, keep my clients informed, let them know what's going to occur in the future. After doing this for 32 years, I have found out that, first off, being involved, even in a case that you're going to ultimately be successful in, being involved in any litigation is stressful. And not knowing what the future is going to hold is stressful. So when I tell clients and talk to clients and keep them informed of what's going on, but not only what's going on, but what the next steps are, and when this happens, then X, Y, and Z is going to happen after that, and they know that. And so then when X happens, they know that was going to occur. Like we've talked about Social Security, disability before, and statistically speaking, you're going to get denied a second time. When I meet with clients initially, I tell them, I said, look, you're going to get a second denial. Don't get discouraged. You've got to get that second denial to be granted. That's just the process you've got to go on. I tell them that because I don't want them to worry when they get that. It's the same in the workers' comp case. You've got certain processes that you have to go through. They're going to send you to a doctor of their choosing at some point in time, in all likelihood. Okay, we've got to go through that, and then this what happens after that. And so the clients are aware of all of that going in, and it just lessens the worry on their part, the stress on them from doing that. And then obviously I want the results to be the absolute best possible. And when I keep in touch with my clients are also keeping in touch with me about what's going on with them. And by doing that, I know that they may have a new issue that if I didn't reach out to them or my staff didn't reach out to them and talk about what the next steps were, and they say, oh yeah, by the way, the doctor sent me for a nerve conduction study because I started having pain going down my leg, and he thinks I may have a herniated disc now. Well, if we didn't reach out to the client and they didn't call and tell us that may be something that if they went to a completely different doctor I didn't know about, I wouldn't know to get those records and to factor that into what their claim is worth and what we need to be dealing with for them. So it helps out everybody when you keep informed and everybody's up to date and kept informed.
So much of it comes back to good communication. It's something I think
Yes.
you do extremely well. So, all right. Well, Jeff, it's been a pleasure. Thanks again for your time. And friends, if you're listening to this, I appreciate your time as well. I'm always encouraging you to, take a moment and consider sharing this episode out on your social media. If you've got a Facebook page or something like that, and you wouldn't mind sharing these episodes, it sure would help us down here because it allows other people that you know about, that you care about, that you're connected with to find out about the Roberts Law Office and the work Jeff Roberts is doing here in our part of the state. So once again, thank you very much for listening. We'll be back in a couple of weeks. Take care.
Thank you.
Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.